Thank you everyone for joining us for today's webinar, which is Employment Law Risks in the COVID-19 Era. My name is Allison Mitchell and I am part of the Greater Kitchener-Waterloo Chamber of Commerce team. Before we start our webinar today, there are a few housekeeping items that I'd like to go through. Your microphones should be muted, but if you could please double check that they are muted to reduce background noise, that would be great. Please feel free to ask questions throughout the webinar by typing into the question box that's in your control panel. And all webinar registrants will be sent a recording of this webinar after the event. Our speaker for today's webinar is Nina Gupta. Nina is an award-winning lawyer at Gowling WLG Canada who focuses her practice on employment, labor, and human rights matters. Since early March, Nina and the multidisciplinary team at Gowling WLG have worked on helping businesses deal with responding to COVID-19. When not in the office, Nina can be found at the horse barn, shoveling manure and calming large animals. She considers these skills to be completely transferable to her day job. I would now like to invite Nina to begin the presentation.
Good morning, everyone. And if we could just add one housekeeping matter. If you have questions, I recommend that you use the question box in your GoToWebinar control panel right here. And Allison can sort of monitor the questions and remind me to answer them. We'll try to get through as many of them as we can. So some of you may have been involved with the webinar we did yesterday, which really focused on government support for employers. Today's panel, however, really focuses on kind of what we haven't focused on, which are some of the employment law risks that we are facing and that we may face later on. And I thought what I would do is really kind of give you a sense of what I want to do. I mapped it out last night. Is I want to talk a little bit about the fact that lots of people are considering temporary layoffs. Some of them are considering permanent layoffs. I get lots of questions on these new job-protected leaves. And then on the other side, I get questions about mandatory overtime and excess hours per week. There's ubiquitous questions about medical notes and abuse of the system, vacation pay, a little bit about EI and supplementary unemployment benefits, a little bit about remote work. So it's intended to be a fairly broad overview of some of the issues that we are facing, and frankly, we don't necessarily have all the answers yet. Now, it's particularly important for you to know that I'm not trying to give you legal advice. This is really a high-level overview, and legal advice has to be specific and tailored to your situation. So we're just trying to raise issues and possible directions of the law that you need to know as you're making decisions. But if you're making specific decisions, you need to talk to your own lawyer, and in many cases, your accountant. Also, I will be focusing predominantly on provincial regulation, recognizing that each province has their own variation, and there's one slide that will give you a sense of how varied it can be, although my focus will be predominantly Ontario. Some of you may be in an industry that's governed by federal laws, such as interprovincial trucking or pipelines. Some of the rules are very similar, but I will not be specifically dealing with the Canada Labour Code situation. And above all, if you're unionized, your first place to look is not the employment law, but your collective agreement. And quite frankly, in times like these, your relationship with the union rep is critical in responding to this crisis. So the first thing we got asked about, sorry, I just realized my slides are not advancing, so I'm just going to give me, okay. Let me see what I can do, if I can get my slides to advance. There you go. All right. So, every province has rules about what constitutes a temporary layoff. Unfortunately for employers, the employment standards legislation is considered to be a floor or basic right. And in all the common law provinces, the common law courts actually treat a temporary layoff to be a breach of contract, because the fundamental contract between employer and employee is that the employee works and the employer pays. So if the employee is being told, we're not going to pay you, or we're not going to give you any work, then it's considered to be a breach of that fundamental employment arrangement. Now, here I'm talking about 100% layoff without pay. Okay? It's treated as a type of breach of contract. Now, there are exceptions, which is the written contract can have a layoff provision. And I was pleased to see a contract that I had drafted probably 3 years ago, which explicitly had a language which talked about, we try to avoid layoffs, but if they're unavoidable, we will certainly lay you off and call you back in accordance with the employment standards legislation. So that then says, okay, we told you, part of the contract is from time to time, you may be laid off. So that's number one. Number two is industry practice. There's a number of industries where layoffs are in fact common, and construction is probably the most important one to think about in our economy. And finally, specific rules in the legislation, which may be an industrial base. And we don't know how the courts will treat the vast number of COVID-19 related closures, but it is my belief, or perhaps it's more of a hope, and I'm a Pollyanna, some of you know me personally, you know I'm more of an upbeat person, is that the courts will treat COVID-19 related closures a bit differently than they did in 2008 and 2009. And number one, and maybe this is cynical, the courts themselves have been shut down. Now, judges are probably still getting paid, but judges are aware that their ushers and their registrars and their frontline clerks and the security guards are facing layoffs too. And while that might make them sympathetic to employees, it also makes them sympathetic to employers who are facing unprecedented challenges. Secondly, and this is kind of interesting, many of the businesses in this province are closed because they are not considered to be essential. So if you think about all the restaurants, nail salons, retail clothing stores that are the mall that are closed because they're not considered to be essential, that has to play into it. There are concepts, which I won't go through it, it's a bit like a Law 101 course, but there are concepts like force majeure, which is a fancy thing about the contract was really ended not by anything you did or I did, but an overwhelming force, almost like an act of God. And there's also a concept of frustration, and there's a debate in the legal community whether or not frustration applies to permanent change of conditions or temporary change of conditions. And however long March and April seems to be, we know that there is a post-COVID world. So one cannot say that this is permanent. So all of these legal concepts will come into play. And any lawyer who tells you that they know how the courts will treat these closures is really being unbelievably arrogant, quite frankly. Earlier on, and I just thought, I mean, many of you just operate in Ontario, so that's, easy. So Ontario, the statutory minimum for a layoff that we just talked about is 13 weeks up to 35 of benefits or other valuable things such as partial compensation are continued. But you can see how different we are. Really a federation that is very different. So you can have a shorter period of layoff of 6 days before it turns into a termination, to as long a layoff as in Quebec, which is 6 months. Little word on Quebec, although most of you probably don't operate on Quebec. It's the only province which has codified the right of layoff in economic circumstances. So in Quebec, employers don't have to agonize about whether this is a breach of contract, constructive dismissal, what the courts might do, because they've codified the right of layoff in these circumstances up to 6 months. And that's not just COVID-19, but it could be other circumstances as well. So what are the implications of layoffs? Well, one thing that you need to do, and we're not quite there yet because most of the layoffs started around March 15th or so. But one thing you need to know is if a layoff exceeds the time period in the legislation, and for us, again, it's 13 weeks, up to 35 if benefits continue. If we exceed that, it automatically becomes a termination. A second word about layoffs is that written notice should be provided. And while we typically encourage you to propose a recall date, or even if you can't do that in the COVID-19 world, we encourage you to put in the written notice how you will contact people, how you're going to keep in touch with people, and that you intend to recall them so that it cannot be misinterpreted or misconstrued as a permanent termination. But if you exceed the time period, and again, for COVID purposes, we're not there yet, so it would only be an issue if you had started the layoff earlier than March 15th. It's treated as a permanent termination, and that triggers at least your minimum statutory obligations upon termination, so notice and severance. The other thing that you have to think about is that if you have a number of permanent layoffs or terminations, whether they're deemed or not, you need to worry about mass termination requirements. And those are special rules regarding, quote, posting, regarding advising the Director of Employment Standards. So just because most of you are working with Ontario-based companies, the mass termination rules trigger at 50 employees in one 4-week period, and there's special notification requirements under the Employment Standards Act. But what most of us lawyers fear, and quite frankly most of you fear, is not the Employment Standards Act, but any common law notice or compensation in lieu. And while the courts say don't use this, just for today's purposes, notice for short-term employees is 1 week, roughly 1 week per year of service. And then you have severance obligations if you're a certain size of employer, 2.5 million payroll in Ontario. It is 2 weeks per year of service after the employee has had 5 years of seniority. And that seniority, or service, sorry, I should say, can be stitched together. So it could be different periods of service stitched together to make that 5 years of service. Common law, by contrast, many judges feel that every employee should get a minimum of 8 weeks, even if they've been only around for a month. Short-term employees can easily get 3 months. And in the COVID world, I think short-term employees might get as much as 4 months. Again, we don't know what judges are going to do. So the issue will be whether or not a layoff in these circumstances will constitute some kind of constructive dismissal, or whether it constitutes a breach of contract. And the two concepts, by the way, are not the same. And what I mean by that is constructive dismissal allows an employee to say, hey, this is just like a termination. I don't have to put up with this. Give me my statutory notice, my statutory severance, and my common law, and I'm out of here. So it's kind of the most extreme case. Now, there's a concept even with constructive dismissal that employees have to be reasonable and mitigate. And in COVID-19 cases, it may well be that your response is, I don't agree with you, but come back and work. And if you refuse to come back and work, we're going to treat it as a failure to mitigate. And I think judges will be very sympathetic to that. A more difficult question is, what about the loss of pay, whether it's total or partial, during the period of layoff? Many employment lawyers, and I don't dare do it. If I were more confident in technology, I would actually flip over to an article written by a worker or employee side firm that essentially says, here are all the ways that we're going to litigate against employers after the courts reopen. My response to that tends to be, don't be so quick. I think judges are going to expect some good faith and reasonableness in the face of a declared emergency. And you have to know that I work in a law firm. We have lawyers who have up to 50 years of service. And only one lawyer remembers a declared emergency, and that is when Pierre Trudeau, essentially invoked the War Measures Act in Quebec. So that tells you how weird this situation, how anomalous the situation is, and I don't know what the courts will do. And I think the plaintiffs' lawyers are being far too optimistic. I will admit that the rules are stacked in employees' favors, but I also think COVID-19 is different than every other economic cycle I've seen. And although I don't have 50 years, I have now over 30 years of service. So I've just left on the screen some of the things you need to worry about if you go to mass, and then I'm going further mass terminations to remind you that depending on the number of employees, it may lengthen the period of notification under the statute. And one interesting thing is typically you have to post, and the law means find a bulletin board and a thumbtack and post these requirements. Many workplaces are essentially closed or ghost. In other words, there might be like Gowling, WLG, which has an office of about 150 people or 125 people in downtown Kitchener. I think we have 3 employees there who are doing essential work that can't be done via remote. So I could post it in the kitchen, but I know that most people won't see it. So it'd be interesting to see what they do about posting requirements. But let's leave that. And I'm really hoping that we don't get to the 13 weeks if you haven't continued benefits, or 35 weeks if you have continued benefits, and that we will all be working and recalled to work much quicker than that, so we don't have to deal with this. Most of you are familiar with this, but I thought it would be helpful just to put it on a slide as I move off from layoffs. And before I move off layoffs, I thought it would be helpful. Allison, do we have any questions yet?
There was just one, a couple are coming in. One person asked whether you'd be speaking to frustration of contracts in relation to layoffs.
Okay, so I think I sort of briefly mentioned it. Maybe what I'll do, because the question's been asked, frustration is sort of similar to force majeure, but force majeure is more like an act of God, something external. Frustration can be more modest than force majeure, and it's often used just when an employee is too ill to return to work in the foreseeable future after a long period of innocent absenteeism due to illness. But historically, frustration has been used in context of permanent closures or permanent changes, as opposed to what we believe COVID-19 will be, is a 2 to 6 month disruption. So, an example, there's cases in Ontario where they talk about a fire that destroys a plant, and the employer tries to use the word frustration, and the courts haven't actually gone with it. And I think in the back of the mind is the courts are thinking about something like, oh, you could have gotten business interruption insurance. I'm not so sure, and if there's an insurance professional on the line, maybe they can use the question box to respond. But one of the things that I don't know is whether you can get COVID-19 or pandemic interruption protection, or if there's kind of insurance that would have been available had we gotten it way back when. Any other questions?
Yes. Is mass termination triggered if you are doing a temporary layoff?
So it's not a temporary layoff that triggers the mass termination. It's when that temporary layoff becomes a deemed permanent layoff or deemed permanent termination, and I'm using those two words synonymously. Then it triggers potentially, if you fall within that 50 employees in 4-week period, it triggers the mass termination provisions. And you also have to have anyway, yes, so that's really, it's not the initial temporary layoff, it's only when, through the effluxion of time, as one of the judges likes to say, it becomes a deemed permanent layoff. Okay.
And then there was a question, what about organizations that have less than 50 employees?
You'll never, even if you terminated everybody, you'll never hit the mass termination threshold.
Okay.
Okay.
There's another question. There's one more. You may be getting to it, so maybe I'll just ask and then you can.
Sure.
Can you advise what to do when employees claim that they can't return to work when they are called back for various reasons, including a spouse who is high risk, or they claim that it is not safe to return to work?
Okay, perfect. So I will be dealing with those, so let's keep that question in mind as we go into the new job protected leaves. So this has been very problematic. The question that the audience member asked is when people don't want to come back to work when they are recalled. First of all, people are taking job protected leaves for completely legitimate reasons, including the requirement to self-isolate because they or a family member to whom they have been exposed are required under the public health rules to self-isolate. They've been diagnosed with COVID-19, which is actually quite small, or they have a presumptive case, which means they fill all the text boxes, but certainly not everybody who has a presumptive case of COVID-19 is getting tested for it. They need to care for a minor child, and this is a big issue. If you have children who are, and I don't know what the threshold is, but certainly 12 and under and perhaps 14 and under, you may not be comfortable leaving them all day, and the schools are closed, daycares are closed, so you have a child care obligation. And finally, you have a care obligation, so you're taking care of somebody who is sick. All of those reasons provide you job-protected leave to deal with it. Here's the problem, though, is the same legislation that did that also said you can't ask for doctor's notes. Now, we all know that doctors hate giving notes. It's sort of not what they went to med school for. And this is going to be compounded by the fact that doctors do not want you to come to their facilities at all. Lots of stuff is being done by way of telehealth or even Zoom calls, or I don't know, maybe they're using GoToWebinar too, who knows. Some jurisdictions like Ottawa just issued a blanket medical note that if your employee claims A, B, and C, please accept this as the medical note. And even medical notes for other conditions. So for example, you might have somebody who claims legitimately that they've had a stroke and they will need X number of weeks off. You're not going to be able to get any kind of medical note from that. So what I've recommended to people is you want to get a formal written confirmation from employees indicating that if they are effectively perjuring themselves or misleading you, that is considered to be a serious misrepresentation and will be considered to be cause for termination. I don't know if a judge is going to uphold it, but I want them, the employee, to know what management's position is on a lie, right? So that's, but many people, quite frankly, have legitimate reasons. The other problem we're facing, and it kind of ties into what we discussed yesterday in the subsidy, is many people are actually, when they get their CURB payment, if they're part-time employees and on their minimum wage employees, overall, they may be pretty well the same or better off by taking the CURB payment. So they're incentivized to actually stay home. This is problematic for us as employers to get work done. So I don't have an easy answer for that. I mean, people who were on the call yesterday know that I'm a bit of a political junkie, so I was watching press releases and press conferences, and, people are all over this, but I don't know how to deal with a situation where employees can make more money or almost as much money by sitting at home not working, and so they don't want to be recalled. The other thing is, and it isn't in the question, Allison, but it's sort of a appropriate riff on the question, is you may not be able to give somebody full-time work. So you were giving people 5 days of work, and now you only have maybe a couple of days of work. So they're in a very difficult position because that couple of days of work currently disentitles them from CURB. On April 6th, Prime Minister Trudeau acknowledged that was an issue and promised to deal with it, but it has not yet been dealt with. So I don't have an easy way to get around that issue. And in my view, it's an economically reasonable response to say, I want to help you, but I can't afford to come in just for a day or two and lose my CURB benefits. Contrast this to EI, where in fact you are allowed to earn something, and there's kind of a sliding scale of clawback or reduction of benefits. So you're always better off, at least a little bit, working. So I don't know if that fully answers it. One other thing this is a good question, people refuse to recall and you do not believe they have a legitimate reason or they're not properly articulating it, then you start doing that discipline process and you essentially terminate them for failure to come back. But you asked an interesting question. They don't feel it's safe to refuse to come back to work. The Government of Canada has made it very clear that you can use the word quit on the record of employment in those cases, so that I can't remember what the code for quit is off the top of my head, and they will be disentitled from CURB benefits. Now, you actually have to be reasonable when you use that because you will be challenged about those cases. So if you have somebody who's immunocompromised, somebody who has asthma, somebody who has a very sick child at home and is worried about bringing stuff, there's got to be some give and take about those issues. So HR is very busy navigating those issues with their employees, and each situation, unfortunately, has to be dealt with on a case-by-case basis. So I've done a little note about doctor's notes, and then I'm going to just move on if there aren't any other questions, Allison, to my next topic.
There was just a follow-up to that one question. So if they are not job protected and they're being recalled and they don't return, then can the employer claim job abandonment?
Well, I would say just quit, but yes, you can claim it, but expect there to be a fight about it because you can expect your employee to come up with a clever reason as to why they didn't come back. So what I would do is ensure that we have a pretty good paper record which tells them, A, you need to come back, and B, if you're not coming back, we will treat it as a quit, and C, we don't accept your reason for not coming back as legitimate.
Okay.
Okay.
Go ahead. There's one question about what you've already talked about. Would you like me to ask that now?
Sure, and then I'll see if we have time. I'm keeping in track of time, but yeah, for sure.
If you are not going to bring back an employee, when is it best to give the written notice so that severance does not need to be paid 2 to 3 weeks before the 13 weeks or prior to that?
Well, if you know, this is a difficult issue in these current times. Cash flow is very important. As soon as you send a notice that we are not recalling you, so, you know, we've lost a permanent line of business that we hired you for and we don't have any work for you to come back to, then, you know, in normal circumstances, I would say just tell them right away so they can start their job search, et cetera, et cetera. But right now, you may not have the money to do that. So the ethical answer is as soon as you know. The practical answer may have to be do it like in week 12 to say, or week 34, the case may be, that I'm sorry, there's no work to do it. Now, I'm encouraging employers, my clients, if they know right away to tell, and they can afford to pay salary continuation and notice and severance and so on and so forth, just do it. You know, there is a thing called karma. We have all of us have a brand as an employer, and we do not want to be perceived as being sleazy employers, because later on we will want to hire people and memories are very, very long and we will have a bad reputation. But legally you could do it in week 12 in that example. So I just wanted to go a little bit about work sharing. And I don't know how many people are even contemplating that, because various programs that were established before, and work sharing is an old program, it's been around for a very long time, don't actually work well with COVID-19 and all the new programs that are being established, like the Canada Emergency Wage Subsidy or CURB. So work sharing, though, at its heart is we have less work for our employees to do. We have a group of employees who can perform similar tasks. We can't keep them 100% busy, but maybe we can keep them 80% busy or 60% busy, and we'll pay them for that 60% or 80% or 90%. And the employee can get EI on a prorated basis for that remaining percentage they're not working. So it's kind of like compensating for a partial layoff. Now, initially, a lot of people thought about work sharing because we didn't have the Canada Emergency Wage Subsidy, and the earlier 10% subsidy we talked about only hit small businesses and was considered to be insufficient. And applications were being reviewed, and I believe are still being reviewed very quickly within 10 days. And the government's added application form was significantly simplified, and government officials were instructed to essentially work with the employer who was trying in good faith to set up a work share plan. We didn't need anymore to have all the data saying, you know, my sales have dropped and here's my 2 years of sales, or we didn't even need at this initial moment to have a formal recovery plan. So work sharing initially, and I would say from March 15th to about the beginning of April, was very popular. Now, there's a couple of things that you need to know about. Is the the Canada Emergency Wage Subsidy that went into law on Saturday has a provision that any amount that an employee receives by virtue of a work share plan will in fact reduce the employer's emergency wage subsidy entitlement. So I'm not going to go through the math, but it's dollar for dollar. So you really need to run the numbers, as I said yesterday, to see whether it's worth your while. We also talked yesterday, but I know not everybody was in the call, about supplementary unemployment benefit plans. And I really think that this is a great program whereby employers who have some money will top up EI benefits without actually having the employee's EI benefits go down. But here's the problem. There's a couple of problems. One is you can't, as of today, top up CURB benefits, and we know that everyone, whether they are unemployed due to COVID or not, if they are essentially laid off due to lack of work or terminated, they will get CURB benefits first and then segue into EI benefits. So we have a 16-week period starting March 15th, or possibly longer if the employee is laid off or terminated later, whereby there will be no eligibility as per today for sub payments. One of the things somebody came up with is, well, what if we loan them the money, hoping that the change came, and then if the change came, we would consider it to be a top up of the CURB payment. If the change did not come, we would consider it a forgivable loan, and at that point, if they came back, we'd forgive it, therefore it'd become, and if they didn't come back when recalled, we'd expect it to be repaid. Good luck collecting, by the way. So on and so forth. I would say consult your lawyer or accountant before you do that, because I have concerns about whether or not that could be considered to be an effort to game the system. And there are general anti-avoidance rules in the Income Tax Act. Are we gaming the system? But having said that, it's we have to look at each case separately, and your lawyer and your accountant may be the best person to go through your own situation as to what you're trying to do and what works and what doesn't work. And I've left the link at the bottom about if you decide you want a sub benefit. Some of you are aware of sub plans. You may already have them for parental and maternity or sick leave. Please note that those sub plans actually didn't need approval. Unfortunately, sub plans to top up people who are unemployed, laid off, terminated, etc., do require formal approval. But actually, the Government of Canada has thrown additional resources to it, and so it shouldn't actually be too long. I actually know somebody that got it approved in 3 days, which is unheard of. And they actually got a call back from the unit that was approving it. So they really have thrown resources, so that comment about normal delays or 2 weeks may actually no longer be accurate, because they've actually now thrown additional resources to the sub-processing unit. Sub-plans are considered to be retroactively approved to the date of submission, so that's a really good thing. I really encourage employers who think they might be in here for the long haul to consider whether or not they want to put in a sub-plan. Now, we've been talking a lot about work shortages and what do we do with work shortages, but I actually am getting huge numbers of questions about, can I force employees to work longer than usual? And this is a situation where you have a number of workers who might be self-isolating or seeking a leave due to child care. On the other hand, you may be in a warehouse or a distribution center that actually has more work. The definitions differ. This is definitely one you want to call your lawyer to see whether or not you fall within the definition of a true emergency. I have to tell you that I do not think you can continuously force people to work excess hours just because it's COVID-19. I think COVID-19, in a bizarre sort of way, is a new normal. And so you would have a really hard time to essentially force people to work, double shifts. Now, I'm not speaking to places that are like long-term care homes or hospitals, ambulances, power workers, where I do think that you could probably say, look, we're an essential service, and if we don't do this, people die or they get hurt. I'm talking about grocery stores, distribution centers or warehouse delivery personnel. I think this is a new normal, and I think the Ministry of Labor will really look carefully as to whether or not this is truly an emergency or just a new normal. Another thing that people have said is, what if we force people to take their vacation time? And let's be honest, and I did have a look at least at some of the people who registered yesterday, because they told me that they had registered, so that's nice, thank you. And those companies do not force people to take vacation. They typically have a process by which vacation time is submitted and approved, and everybody agrees when people will take vacation. But one of the things that people are considering to do is they've already budgeted vacation time, or they've kind of accrued it on their books, and so they want to force people to take it because it's a period of time that they will have 100 cents on the dollar. It essentially removes the obligation or threat of, you should have paid me full pay. Well, you got your vacation pay and we called you back. I get less of those questions now because I think we know that we're in it for the long haul. The Premier yesterday announced another 28 days of COVID-19 closures. And so, using the vacation or forcing people to take vacation right away isn't as much of an advantage to the employer. But in general, there's a principle at law that employers can essentially choose when employees take vacation within reason. And one thing is, if you're forcing people to take vacation, it is treated as employment from income, and it delays CERB and or EI eligibility. But that's a useful thing. Many of us, including probably the vast majority of you who are listening in via GoToWebinar, and myself, who's working in the dining room, so you may have heard some background noises from the kitchen next door, are working from home. And there are a number of health and safety considerations, including ergonomics for office workers. And I've given you sort of I apologize, but my computer thinks it's smarter than me, which it normally is. I've given you some useful links about ergonomics. I've given you a link to our article on confidentiality because while this seminar, I don't mind my family members listening to it, but they'd be bored stiff, I'm sure. But what if you're dealing, like I am, with a difficult sexual harassment case or a difficult financial transaction that has implications? How do you protect confidentiality? And then there's a useful, I really like this checklist. I know it's US published, but it's actually really a great tool. And finally, if you're in a regulated industry such as banking, law, healthcare, you have additional requirements regarding record keeping and confidentiality, and I recommend that people go to their own particular governing body to see how they are suggesting you deal with these requirements. So just a couple of things about safety. If you are not an essential business, you need to be closed, or of course you can telework. I get asked quite frequently, and I joke, but it's also true. I did not get a free medical degree, and I certainly didn't get my specialization in public health when I graduated with my law degree. I do have a basic occupational health and safety training. But if you are concerned about a possible presumptive symptomatic employee who has come into the workplace, you need to call public health. And I need to tell you, they are not looking to close down essential businesses unnecessarily. So if you're open and you're concerned, talk to public health. My next slide will have the contact information. Obviously, you encourage people to stay home when sick or symptomatic or exposed. Clean scrupulously. We're not on webcam, but even at home, I've got my Lysol wipes and my hand sanitizer. I know this is a bit kind of flip, but remind people, nag frequently, have those hand washing posters up. Your mother and your grandmother were right. And I wanted to just share something personal. My mother was a germaphobe, and it was really irritating. Like, she made me wash my hands, change my clothes every time I came home. It was very annoying, and it was a source of great tension. I realize now where that comes from. When my mother was very young, so I think she was, this was before World War II, she got diphtheria, which is a highly infectious disease. And what kept the rest of the family from becoming ill were all those precautions we're now using against COVID-19. Diphtheria now is virtually unheard of in the Western world because there is a vaccine for it. But my mother was pre-vaccine and infected pre-penicillin, so it's a miracle that she survived till she was 80 and had me and all those other good things. But the reason why the rest of the family survived was because they did all those precautions. So here's the public health information line if you have a suspected case of COVID-19 or you want to know what you should do in the circumstances. And there's local information, and I just put this out of interest, quite frankly. And I'm going to see, okay, I'm going to try and see if I can do this online. This is a site that gives you localized information regarding the spread of COVID-19 in Waterloo region, as well as the sort of the breakdown of who's getting infected and how. And it's kind of an interesting read because if you're a news junkie like I am, you're probably seeing the national and provincial statistics. And I'm going to just try to throw this on the screen for you, but I just found this and I thought it was really interesting because this has the local statistics. So you see the cumulative cases, 379. Then you can go down and you see the breakdown of who's getting infected, and you can see who's being hospitalized in the ICU. And then you see cases by age. I don't particularly like this statistic. 22% is in my demographic. Then you see the issues with respect to long-term care facilities. So I thought it was kind of an interesting site. And Public Health updates this every day. So it's very information. One of the things that I thought, and I wanted to end here and open it up for questions if there are any. If there aren't any, that's okay too. We can just get started on the rest of our day. But, and this may be just a fluke, but these are new cases by symptom onset. And this is maybe one of the most important statistics. And I believe, maybe I'm being optimistic, I said I was a bit of a Pollyanna earlier on, but there was a spike over the weekend, and then I'm hoping that we are seeing the beginning of a drop off. In other words, I'm hoping that we're smashing that curve in Waterloo region. So, and I think I'm going to see if I can close this. I have the link in the slides, and I know that, oops, just see what happens when I try to be tech savvy. It doesn't work very well. Okay, one more. I'll move this over and then you can see it. So this is the full presentation and the line, and I think that's an important line for you to know if you think you have concerns in your workplace. I've given you my contact information, but quite frankly, you can always send questions to the Greater KW Chamber of Commerce, and they'll send it to me. Allison, do we have any other questions before we sort of sign off this morning?
We do. Okay, so one attendee, we are a tech company, we have work, but what if employees refuse to go on site because they don't want to go outside? Well, I mean, again, if you can do it, I really encourage people to be a little flexible in these days, and if they can do it remotely and they're doing their job remotely, to let them do it and not make it a fight. Remember, you're trying to be a good employer and a good citizen, but sometimes work can't be done, or quite frankly, you don't think they're actually very productive because they're half the time they're distracted by children, dogs, and cats.
then I think that unless public health has a concern, if you're maintaining the social distancing, you formally recall them and you go through that written documentation. But you have to balance the fact that there will be a post-COVID era. There will be an era where you need these employees, presumably, and so you have to work out these things on a human level as well as a legal level. But the legal answer is you document and you ultimately fire if they don't come back and they don't have a legitimate reason. But I found out information, honestly, about employees that, has never been an issue before. People who look perfectly healthy have disclosed, listen, you may not realize it, but when I was a kid, I damaged my lungs due to some infection and disease, and I'm actually vulnerable, and so I'm ultra scared. So you have to work with those people on a human HR process. And so I encourage you to consult with your HR people about how to work out people or allay concerns.
Okay, next question. How similar do jobs need to be shared under the work share program? So could a controller, accounts payable, and a cost accountant in a small finance department be considered one unit? They have different skills and job expectations, but they do back each other up.
I think the question should be turned on its head, in the sense that are you able to actually share the work in a meaningful way? Are these three people able to share the work in a way that makes you comfortable in saying they're work sharing? Typically, though, they tend to be more peers than the kind of example that was given by the person who posed the question. But if you are seriously thinking work share, I would put the application in, and the officers are really good. One thing that we're not going through in great detail is that it may not be worthwhile, and particularly for the most senior person in that group, because EI benefits are clawed back if the person earns from all employment sources $67,750, I think that's from memory, or more in 2020. So if you have somebody who's probably going to earn more than that, they may be facing a clawback unless they haven't used regular EI benefits in the last 10 years. So I would have a pretty candid conversation with the people who, if there's some people there that are earning in that range, or you expect to earn at the end of the year that $67,750, I'd have a pretty candid conversation as to whether work share makes sense for that person.
Okay. What can employers do when they suspect that an employee is not practicing physical distancing on their personal time and is entering back into the workplace? This would be a health and safety issue.
So there's a conflict between health and safety and a conflict between, employment law, which requires warnings and stuff. I'm going to give you my blunt answer, and that may be an answer that exposes that, of course we would talk about specifically, but I can tell you what my gut answer is. And my gut answer is, you say, well, we believe that you are not taking the appropriate precautions, and we are not willing to expose ourselves, or we are not willing to expose ourselves and our workplace to that risk. So you're gone. You continue on. You're put on layoff until further notice. And they might squeak and they might say that this is a wrongful termination, but you have to balance the health and safety of everybody else. And I'm hoping that you have, real reason to believe this, and it's not just some flimsy rumor. But, we all saw the idiots on the Florida beaches. We all have seen Facebook postings, and you're sitting there, despairing of the human intelligence, or I am. But anyway, neither here nor there. I think that you have to err on the side of health and safety. I think you should have a conversation with the employee first, because the rumor mill can really build up to fever pitch when we are faced with a pandemic. But if you continue to have that belief, and it's an honest belief that the person is not serious about social distancing, then I would not hesitate to say err on the side of health and safety. But again, that's one where we would work out all the facts, and it needs some nuanced discussion. I have to tell you that that I was never more proud of Waterloo than when I saw the students who didn't show up to the March 17th St. Patrick's Day party, in contrast to the people in Florida. I really, really have to say most people are taking this seriously, so I'm hoping that most of us are not facing this concern. Do we have other questions, Allison?
Yeah, we do. How much written notice is required before temporarily reducing hours and compensation for salary employees, and they're not going through the work-share program?
Okay, so yes, so you're doing a salary reduction, and I can give you the ideal answer, then I'm going to give you what I think most employers are doing because they have to. The technically correct law school answer is a salary reduction beyond, I would say, 5 or 10% is considered to be a material change in employment conditions, and therefore you should give the same notice that you would give A, under the ESA, or B, under the common law, whichever is greater. So that's a law school question. However, the law school answer doesn't work for us because we don't have 1, 2, 3, 12 months or 24 months of notice that we can give to people. And so then what I say is you give as much notice as you can. So it's usually, you know, I've had clients who have said, here's the notice on Friday, and on Monday we're all facing a 20% pay cut. This is why we didn't want to do this. We try to avoid it, but we're looking at our financials and we need to do this, and we just live with it. And that's one of the things that if you read, you know, I'm not going to try it because we've proven how bad I am at using GoToWebinar, but there's a employee side lawyer who says, well, that will open up lots of class action suits. And that goes back to my discussion. I think the judges will be much more sympathetic to employers for COVID-19 than they were previously.
Okay. Another question. Given the Ontario requirements regarding domestic violence prevention, the current work from home and stressful COVID-19 situation, are there any increased concern for employers? And if so, are there any recommendations?
You know, it's a very serious question about domestic violence. I have actually recommended people go to public health as to what they recommend. So, for example, our office theoretically could remain open because we're in a law firm, but we've chosen to try to assist in the whole exercise of smashing the curve of working remotely. So for those offices that are permitted to be open, then we talk about whether or not we can allow them to come back in, even though that is not our employment policy, because there's no law saying we have to remain closed. What happens when you have a business that, you know, that cannot be open unless they're teleworking? And I don't know what the answer is except to call social services and or public health and say, what do you recommend? Because I don't think that, you know, if you're correcting, is there going to be additional liability to the employer? I don't think there's going to be additional liability for an employer because you're following the law, which says you have to be closed, and you're permitting employees to telework. Obviously, if the employee says, I can't telework because I have to run away from my spouse who is beating me up, you are going to facilitate that and not punish her for taking her leave. But I don't think you can open up your workplace without some governmental authority saying, yes, you can open up your workplace in this circumstance. So the best thing you can do is, you know, essentially permit a person to take a leave, but you can't, you know, you're caught between a difficult place because you have the situation of being required to be closed, permitting telework, but then having a situation where you're worried about somebody with domestic violence. If you have an EAP provider, this is also something that you might want to refer to your EAP provider. They may have some better hints. And Allison, I'll go and see if we have some resources on domestic violence, and if there's anything useful, I'll flip it to you, and you guys can flip it to the many people who are on this call.
Sure. If we have time for just one more question, because two people have asked the same question,
sure.
And then we'll end it up. And so the question is, can employers make taking employees' temperature a requirement upon entering the workplace?
So, assuming they're an essential workplace and they are allowed to remain open, the jury is out. However, I would say if you feel that you need to do that, because certainly myself, I don't feel it when I have a fever. So, but you would need to establish that policy with some input from occupational health. Because you would need to know what the temperature cutoff is. I actually had to do a temperature check to go into a client's place for a necessary meeting, and I was shocked to learn that not everybody actually has the same body temperature, and there's a slight range, there's a range of what's called normal. So yes, I would say, and we would want to talk about it, and you want to talk to your lawyer and your occupational health expert, but I would say that many companies are doing it and it's being tolerated, and then there's a whole bunch of rules that you'll have to follow regarding privacy and who's actually doing the temperature checking and the reliability of it. So it's not a straight yes or no answer, but in general, I think it will be accepted if you do it right.
Okay, great. So I'd like to thank everybody for joining us today, and a big thank you to Nina for presenting this great information both today and yesterday. We appreciate you sharing your time and expertise to help our business community through this difficult time. To the attendees, you will be receiving a follow-up email with a link to this webinar, as well as the slides. For those who missed our webinar yesterday, you can log on to the Chamber website and you can find a recording of that webinar there. So again, I'd like to thank everybody for joining us. Thank you again to Nina for sharing your time with us today.
Thank you.
Thank you.